Each side, I should say, each party, whatever you want to say, has 15 minutes to present their arguments, and the appellant may reserve up to 5. I'm ready to proceed. We're ready to proceed.
I would like to reserve approximately 6 minutes.
We can only reserve up to 5.
5.
Okay, that's all right.
Apologize.
That's all right.
May I
Oh,
begin, Your
yes,
Honors?
please, I apologize to
Oh,
you.
I'm sorry.
I'm starting to write down stuff and I'm not paying attention, so I apologize. You may proceed.
All right. Mark Owens and I represent plaintiff appellant Tommy Copen in this matter. I would first direct the Honorable Court to the decision of this court in Wayne County, specifically in this case. And this is, the journal entry said, the court has considered the evidentiary materials, the written arguments of counsel in reaching the decision. The court finds that there's no genuine issues of material fact as to the plaintiff's claims. That's probably one of the shortest summary judgment decisions I have read. It gives no direction as to what evidence you relied upon.
I will say, when you say that, I just remember when I was a practicing attorney and I had cases in Copen County, I would get a postcard that said summary judgment granted, summary judgment denied. So when you say it's the shortest, I'm just thinking about those days when I saw that.
Yes.
I know my colleague over here did a lot of practice in Copen County. You remember what I'm saying,
I
Judge?
do.
So,
Certainly for a summary judgment motion on an employment law case, normally there is some analysis by the court.
and I don't mean to imply that's right or wrong. I'm just saying that we do
Correct.
see it. But go ahead.
Normally, employment law cases, as this court is well aware, it involve a great deal of evidentiary material, a great deal of depositions have been taken, a great deal of testimony. And the burden for summary judgment, as this court is well aware, is not high. As Judge Aldridge, the federal court used to say, normally a plaintiff with a well-pled case can hurdle over the bar of summary judgment. In this particular case, it's very clear there are material factual disputes based upon his discrimination, retaliation claims, literally all over the place. In this particular case, Mr. Copen is a truck driver, and he was hired in 2009 to work at the defendant's location, CRW. At his initial discussion about employment there, he stated very clearly that he could not work weekends because of his race car driving responsibilities for his son, as well as he cared for elderly parents. Those facts were all brought out. In fact, it was testified to that they were well aware that he could not work weekends, and the last time he had ever done so was February of 2010.
What was the practice with regard to assigning work duties by the employer? Did he absolutely have a firm commitment that he was never to work weekends, or was there flexibility?
Generally, they were hired. Truck drivers didn't drive on the weekends. They would leave Sunday night and go out for the week. And so
You said generally, but was there a firm policy that explained the weekend situation? Could they be called upon if needed?
I cannot cite anything in the handbook that states one way or the other, Your Honor. He was injured while performing his duties on 4/6/2010. Very clearly, the employer at that point did not believe that he was, in fact, injured, and there's various testimony and comments about the fact that he was disbelieved, that, in fact, on the form regarding the contesting of the claim, they said that it couldn't have happened, literally, and so the employer had a great deal of disbelief about the injury. They proceeded to send him to his to their doctor, and where he was treated, he was reassigned to what was called light duty work, which was actually involved in washing trucks with very long poles. Now this man had a lumbosacral strain as found initially in his first visit, and the doctor in no way said that washing trucks with very, very long poles to get there was something that was within his work capabilities. As a matter of fact, the job description that was sent over was light duty work such as office work, which was never assigned to Mr. Copen, as well as doing laundry, which is also a very light duty, but it would have been within. Unfortunately, for Mr. Copen, the defendant received an updated Medco on 6/22/2010, which said basically to avoid driving. Mr. Copen had no other means of earning a living. Driving is the only thing that he, in fact, has as a CDL. CRW testified that drivers are very hard to find, very important to have drivers, and they needed drivers. So the minute the Medco 6 came in saying avoid driving, along with an MRI that said he had degenerative disc disease and would worsen within literally 3 days on 6/25/2010, they sent a note while Mr. Copen was in the doctor's office asking the doctor to sign off on a new light duty schedule that said all the other duties, but now he's going to work different days, knowing full well that he couldn't work weekends. Now, Mr. Brown testified that he knew he changed that schedule on the advice of his workers' compensation assistant, and then several pages went away. Clearly, when Mr. Brown then went into his office to discuss it, his words were he was not going to discuss changes any further. Certainly that is not appropriate accommodation behavior. But be that as it may, at this doctor's visit, while Mr. Copen was on his back, literally, the doctor signed off on it. Now, this is a very short period of time. Under workers' comp, you must give 48 hours if any changes to a light duty. This happened on a Friday. He was to report after working all week. He was to report the following Saturday morning, that Saturday morning, to in fact work at CRW washing trucks with the wash boys. They had some teenagers on and off come in and wash trucks during the summer. And at that point in time, Mr. Copen said, there's no way I can do that. And he then showed up Monday morning. He tried to call Mr. Brown. Mr. Brown would not respond to his phone calls on the weekend. On 6/28 on Monday, he appears in the office. He has an office visit. Mr. Brown literally tells him to get out of the office. We're not making any further changes because the president and he have determined that's it. At that point, Mr. Copen peaceably left the office and received 3 separate termination letters of a period of 6/30/2010 to 7/1/2010, all stating that he was terminated on 7/1 due to insubordination and refusal to do work. Each one of them changed. Each one of them was slightly different. Each one was approved by the president of the company. We also have testimony from Mr. Wood, one of the owners of the company, that we fire employees who can't drive anymore. So it was very clear that when Mr. Brown received the MRI report that he had degenerative disc disease, which would only worsen, and the fact that the doctor said he had to avoid driving, that he was of no use to him anymore. And at that point in time, the changing of the schedule, which they had never adhered to anyway, literally caused Mr. Copen's termination. And remember, this schedule was changed at the behest and with advice of their workers' compensation representative. And in this particular case, I think it's very clear that when we look at the prima facie case that Mr. Copen would have to make, it can be made by hostile attitudes, it can be made by the totality of the circumstances, anything that seems fishy. To me, the proximity in time is also another very strong link, as well as the fact that there's no legitimate business reason. That is truly contradicted by their evidence that they needed to make changes to the schedule. Actually, what happened is it would actually increase, they testified, it would increase their overtime for a mechanic who would have to be there to supervise Mr. Copen while he was washing trucks. That coupled with the fact that they said it was due to insubordination, due to the fact they got advice of the workers' comp advisor, certainly makes their excuse of it was better for them in the summer. Now, Your Honor, Judge Whitmore asked me whether or not there was anything in the handbook regarding the guarantee of no weekend work. Well, there's no guarantee, there's nothing in there regarding we change our hours during the summer and employees need to work these amounts of time. It says nothing. As a matter of fact, Mr. Brown testified there wasn't even an absenteeism policy. They don't have one, apparently.
Counsel, you're in
according
your
to Mr.
rebuttal
Brown.
time. I'm sorry.
Thank you.
Thank you.
May it please the court. My name is Susan Baker and I represent CRW in this matter. I would respectfully request the court to affirm the trial court's motion or order granting CRW's motion for summary judgment and affirm its decision not to allow plaintiff to amend its complaint and its denial of Copen's request to strike the affidavit of Chris Wood. It's important in this case, I think, that we start with the material facts of the case. The material facts of the case are that Mr. Copen was injured on the job. He instituted and pursued a workers' compensation claim. He was given light duty. His light duty hours of work were changed, and he refused to work those light duty hours because he wanted to go racing with his son.
Let me ask a question now. What was the light duty? Was it strenuous duty? I mean, putting aside what he wanted to do, was it reasonable to expect him to have the range of motion and to do what he was being asked to do that was called light duty?
Yes, it was, Your Honor. If you look at the MEDCO 14 where it says never reaching overhead, that's why he was given the extension so that he could wash without reaching overhead on the trucks. So I think that the facts of the case do indicate that there were accommodations made for his restrictions
Thank you.
of no overhead on that. Mr. Copen was never promised that he would not work weekends. That testimony is in the file. He was hired as a driver. Generally speaking, drivers do not work weekends. However, he was on a light duty assignment at this time. The motion for summary judgment should be affirmed because he cannot provide evidence that there was an adverse employment action against him, which is an essential element. He was offered a light duty job within his restrictions. It was actually approved by his physician of record. And the testimony by Mr. Brown was that we knew that he was there. He had taken Friday off because he said he was having some pain, so he was going to go back to the doctor. We knew he was at the doctor's office. We had discussed whether or not we should make this offer and if it made sense because of the way the business runs in the summer for a trucking company, which is, as Mr. Wood elaborated on in his deposition, there are many reasons for this. There are workload changes. More trucks are out during the week, and they're back home during the weekend. So the light duty work that he was going to be assigned to do involved having trucks in the yard. Why not have him come in the weekend rather than stand around with nothing to do during the week? There were less mechanics in on the weekend, so he could use, they could use the bays to wash the trucks. That makes good sense. The fact that Mr. Hoffa may incur some extra overtime as a result of being in the yard on the weekend goes along with having to supervise mechanics as well. That was his job, and he testified that he did come in on weekends to testify, and he was going to come in on Saturdays while Mr. Copen was there as well. But again, I would point to the fact that there's a legitimate business reason, and there's not been any proof offered that this isn't a legitimate business reason. There's no evidence that the workflow doesn't change with the trucking company. There's no evidence that the trucks are not there on the weekend versus during the week. There's no evidence that there was any, there's no cost savings or no benefit to having less people standing around in a yard during the week than there is on the weekend. And moreover, this is a temporary job. That's what the Medco 14 says, the last one says. It ends on July 2nd. So they're offering him this as he's getting better. This is not intended to be his full-time job. This is something while he gets better.
If the drivers don't drive on the weekends,
The drivers generally don't drive on the weekends.
summer or winter, right?
Yeah, but in the winter more so than in the summer. That's where the workflow changes. They are out more during the week in the summer than they are in the winter.
So I'm trying to get a handle on this summer schedule change. You know,
Okay.
what necessitated someone washing trucks on the weekend versus during the week?
Because the trucks were not there during the week.
All year round.
They send more trucks out in the summer they send more trucks out during the week than on the weekend. They have more trucks out on the road, period.
During the week.
During the week in the summertime. They haul mulch, they haul for Scott's over in Orville. So that's when they're hauling is during the summer. That's the summer schedule. That's the change in the flow of business.
And that's the information that's contained in the affidavit and the summary judgment materials?
No, that's information that's contained in Mr. Wood's deposition taken in April of 2016. The information in the affidavit is just that he, after reviewing the video, he remembered then that it was taken in July of 2011.
Okay.
I would like to
Do you know how many depositions were taken in this matter?
Mr. Wood, Mr. Honka, Mr. Brown, plaintiff, and Kennedy, 5.
So probably several hundred pages of deposition testimony.
Yes, Your Honor. I would like to dispose of the argument that 4121-3-32 in any way requires that an employer given someone 48 hours notice. That provision, it appears in the Ohio Administrative Code under 4121-1 et sec, which is titled Industrial Commission Administrative Proceedings. And it is instructive to the Industrial Commission as to how they are to handle and how it is to be handled when an employer makes an oral offer of light-duty work. They have to follow that up within 48 hours of the oral offer with a written offer before the employer can institute proceedings to terminate temporary total disability as a result of the refusal to accept a written light-duty work offer. The cases that are associated with this that talk about this has to be a good faith offer as well appear under mandamus actions appealing the denial of temporary total disability or the granting of total disability, not in employment law cases. Likewise, the video surveillance that is referenced was taken a year after he left employment. Anything relating to that really doesn't have any evidentiary value regarding whether there was any type of discriminatory action on the part of the employer in making this light-duty work offer. It's a year later when they're fighting this temporary total disability that the video is taken. With regard to 4112.02 perceived disability, again, he cannot show that he was disabled or perceived to be disabled because although he argued both under his assignment there, but he was not perceived to be disabled because he was not considered to be disabled from a large class of jobs. Chris Wood, the owner, testified that he didn't think he was disabled because he was able to work. He was there. He was light duty. He was working. The idea that an MRI that Mr. Brown testified, I looked at it, I put it in the file, didn't know what it meant, and a Medco 14 that has a note should avoid driving. Those are the only evidence that counsel has to bring forth this argument that they knew he was of no further use to them. They fire drivers that can't meet their, and what it is if a driver can't meet their, and the testimony's in there, if they can't meet their CDL exam, of course they can't drive, so they get fired. If you can't pass your CDL physical examination, you can't be on the road, simple as that. In this case, everybody expected him to get better. He had temporary restrictions, that's what the May Code 14 says. So he wasn't disabled because it was a temporary condition. There were no negative perceptions that encompassed a large class of jobs. So he was not perceived to be disabled. He had a soft tissue injury, a lumbosacral sprain, and a contusion of his heel. That's what he had. That's what was allowed at the time. That's what everybody was operating under. So he can't meet that most essential element of a disability claim, perceived or actual. Again, the failure to accommodate argument it fails because there wasn't a duty to accommodate him. The employer has no duty to provide light duty for someone who's injured on the job. If they're temporarily totally disabled, or if they're temporarily disabled but could return with restrictions, if the employer doesn't have work for them, they don't have to make it available. And likewise, even if you viewed the facts and light most favorable to the injured worker and assumed he was disabled, that they did accommodate. They gave him a light duty work, that job that was within his restrictions. If you look at the Medical 14's Exhibit 1 and Exhibit 3 to Chris Wood's deposition, you'll see that the restrictions are actually decreasing. He's moved from no overhead reaching to 1 to 33% of his job could involve overhead reaching at that point. By 622, he's getting better. And that's what everybody expected he would do. Even if he were permanently disabled from truck driving, the accommodations that he asks for he didn't ask for them, but he points out that he could have had these, are not reasonable accommodations, nor are they required under 4112.02 or the ADA. He wanted to be a dispatcher. He has no qualifications to be a dispatcher. They didn't need a dispatcher. He wanted to work in the office. He didn't provide any evidence that he was qualified to do that, nor was there a job. The employer's not required to make a job, displace a person, or choose someone over, a disabled person over someone who's more qualified. They're just not required to do that, and as a matter of law, that's not a reasonable accommodation. Again, the burden shifting test is the same under 4112.02 as it is under 4123.90.
Counsel, I'm going to just stop you if you don't care. In this case, we're talking about a retaliatory discharge, discrimination on basis of workers' comp. We're talking about, perceived disability. We talk about such things as burden shifting and reasonable accommodation, and whether a legitimate non-discriminatory reason existed in regard to whether or not, the light duty schedule was proper, and was there an adverse employment. I mean, there are so many issues in this, and there always are in these employment cases. And I'm sitting here feeling like I'm back in the trial court. I'm not a court of appeals judge, I'm a trial judge, because the only thing I have is an entry that says summary judgment is denied. So to review, because I know we have to know about review, but it's still review. And when I have an entry that just says summary judgment denied, how are we meaningfully reviewing whether the trial court felt like there was no adverse employment action, whether they didn't even meet their prima facie case? How do you actually adequately review something like that?
I think the way you do it is by looking at what is material to the case. What are the facts that are material?
But to do that, I understand that, but I guess my point is then I'm really basically just being the trial judge. I'm saying for the first time, I'll write an opinion. Me, I don't know who's writing it, but I mean, I'm not saying who's writing it, but I'm saying we as the court will write an opinion that says there was no adverse decision, or there was. There was a legitimate non-discriminatory, or there wasn't. They met the burden shifting, or they didn't, for the first time. How is that fair to either side? How is that fair to you or the other side? Because the only avenue of recourse you have at this point is go to the Ohio Supreme Court, and they don't have to accept the case for either one of you.
I think you're already asking me a question about why the judge did what he did, and I really can't answer that.
Well, it's not just, well, he
but
actually...
I can tell you this, that, I don't mean to.
Well, actually, he said for, I think, your side to prepare the entry.
Yes.
So I guess I'm asking you, why did you do what you did, and how does that help us?
I did what I did because I cannot see into his thought process, and I assumed that if the entry that I gave him was unsatisfactory to him, he would let me know
And
that
I'm not
he'd write
picking
his
on you
own.
or making fault with you, I'm not trying to
I mean,
suggest
that was truly my thought
It's
was.
it's not the easiest position to be in.
Was,
I
that
can
was what
appreciate
my, another thing is that, if you read, I'm sure you have read my brief, but that was the focus of my brief. There is no question of material fact here, and as a matter of law, the motion for summary judgment should be granted. So since he asked me to write it, I assumed that he agreed with my brief, and I felt that if he wanted further analysis, he would let me know he wouldn't have approved and signed the judgment.
I understand, like I said, you're in a difficult position, I understand. But anyway, go ahead, you may proceed. I apologize for taking so much of your time on that.
Thank you. And I would just point out again the legitimate business reason. There's been no evidence offered why this would be protectual at all. We've talked about the flow of trucks, and Copen hadn't even worked there a whole year, so he doesn't even have firsthand knowledge as to what happens in the summertime at CRW. So he would have to have come up with something else to create some question of fact, or provide some evidence that this was a pretextual reason. The idea that an employer might investigate a claim, or that the employer conferred with their third-party actuarial, there's no evidence that the third-party actuarial told them to do this. They may have just called to say, can I do this? And we don't know if the TPA said yes or no, and it's not even counsel. So the relevance is just, I'm looking to see about this, get some advice on that. The disparate treatment theory that is argued is also inapplicable. Yes, those people did have workers' compensation claims. Yes, they were provided with light duty, but no, they did not refuse to work the schedules that were assigned to them and were allowed to continue to work. I think that's pretty clear. I think with regard to the abuse of discretion, when it refused Copen's request for leave to amend his complaint, my brief sets out the long history of delay in this case. This case was combined for some reason with the workers' compensation cases.
That was very confusing.
That was very confusing. After that, Copen refused to appear for a deposition. My motion to compel, he said he was mentally not able to do so. Judge Spittler agreed with that, granted the motion to quash. It was then never provided, the employer was never provided any documentation as to when he was going to be able to testify. So the case kind of languished there for a little bit, but was reconstituted as finally Copen elected to pursue his claim in court as we were getting on with the matter of the claim that the workers' compensation claims were separated again because they really shouldn't have been together. Again, the delay in bringing this cause of action and trying to add new parties is very prejudicial to CRW. If you look at the facts of the case, you see that Mr. Copen knew on the day the video was taken that it was taken because he admits he confronted the videographer about it. In November of 2013, in one of the workers' compensation cases, in response to one of the requests for production of documents, counsel for CRW provided that video to Copen's counsel, who is the same counsel in the employment law case. So everybody knows about this video since November of 2013. They've actually had the ball. So the argument that attempting to hide the ball when you've got the ball since November 13 doesn't make sense as far as the delay there goes. There was plenty of time.
And counsel, you're out of time. Thank you. You have 5 minutes.
Thank you. Let me hone in on this last argument as far as we've gotten through some of the factual disputes, and obviously our version of the facts, including statements by management. He was written up for standing around not doing his work after the injury, including statements that they didn't believe him, that Mr. Wood, who was the president, was on his case all the time because Mr. Copen was on light duty and not doing his work. I think those are all statements of animus, and the case law has shown even one statement is sufficient to draw an inference along with the totality of the circumstances that they certainly did not wish to continue to employ an individual that was no longer going to serve any useful purpose. But as to the amendment of the complaint, there actually was a misstatement by, I don't believe she meant to do that. There was actually a total of, as far as depositions, we deposed all of these, the majority of these folks twice. That's why you'll see deposition 2011 versus 2015. And each time, as this case evolved, there was different and new and additional facts that they continued to reveal. So for instance, in the 2015 deposition was the first time that the plaintiff had heard this, what I believe to be a gross invasion of privacy, that in fact, that they took $300, paid someone cash to go and in fact spy on Mr. Copen. So we requested, based on the 2015 depositions, facts of which in many other areas we were not aware of, that for instance, Mr. Brown was parking out. Mr. Copen was on a dead-end street. He was driving by a street to see if he was working. He was watching cameras to see if he was, while still employed at TRW, heading out and watching him get out of the truck to see if he was spraying out of the truck. So this constant, what I would say, investigation of Mr. Copen started from the first moment when they refused to allow the workers' comp claim and said that they didn't believe it happened, that he had complained in the past about a bad back, and then just continued on. As these depositions evolved and additional parties were revealed, for instance, Mr. Brown said he relies on his workers' comp advisor. This Debbie woman is certainly, we had no trial date, and certainly, as evidence shows, we should be permitted to amend the pleadings. But getting back to the prime case, if we concentrate just on the events leading up to the termination and the termination itself, it's very clear that if we just look at that circumstance alone, as the Ohio Supreme Court has recently said in their decision that we brought to the court's attention, that was decided on, I believe it was July 17, 2016, there's certainly enough here that as a matter of law, you cannot conclude, based on just the argument of facts that we've had here alone, that there is no possibility that any trier of fact would be able to solely say that the defendant in this case did not engage in any retaliatory behavior, did not engage in any discriminatory behavior. Certainly, there has been enough disagreement as to schedules. There's statements made, admissions made, comments. He described, Mr. Copen described, that trucks, actually when they say, and these are 18-wheelers, these are not tiny trucks, literally their tires are up to my head, and that's not even the top of the tire. You have to climb onto the tire to be able to use the long extension and hang off there in order to clean the windows. And these trucks were coming in throughout the week, and so he was doing and cleaning those. As a matter of fact, he overextended himself so much that he complained and sought to visit the doctor.
And counsel, you're out of time.
Thank you.
Thank you. Thank you both for your arguments to the court. The court will take the matter under advisement. It will issue a written opinion, which will be sent to both sides, and it will also be released on our website and the Supreme Court website. Thank you very much.